have a lot of bigger employers that employ a lot more people, and you could have a lot more of an impact by passing some legislation that would impact larger employers. And part of the answer, I think, may be the tax credits. Other than that, I really don't know why Congress directed this toward small to mid-sized employers. As you can tell from the slide, it applies to only employers with fewer than 500 employees. And so that makes it somewhat limited, although a lot of our employers fall within that category. The other thing to take note of is that this law is now in effect. We had a couple of week period where a lot of my webinars and things took place before this law went into effect. But as of April 1st, it now is in place. And so everybody needs to be complying with it right now. You all should have also received a poster that you're supposed to put in a conspicuous place. This is your traditional employment law posters you put up on the wall with all of the others that frankly nobody ever reads, but in theory they're there for people to take a look at and know what the law requires. Of course, we're going to jump into that with you today and talk a little bit about those things. And Logan, as you go through, if you have questions, feel free to interrupt me because I'm just going to keep moving, at least at this first part, unless there are questions.
So that notice, will that have been mailed out to everybody already, or is that something they have to go find?
Well, you can find it online. I would check with the DOL. It's in various places, but it has been sent out to some employers. So yes, and you can then just put that up. So it's just a traditional employment law. I don't know, it's about this size and can be posted, but you can find it online. I've seen electronic copies. I even have a copy in PDF that could be sent out if anybody needed a copy of that. So anyway, let's hit the next slide, Drew. Okay, today we're going to be talking about a couple of different laws that fall within this family's first Coronavirus Response Act. The first one is the Emergency Paid Sick Leave Act. I'm a lot of times going to be referring to it as the EPSLA, and I hope it doesn't get confusing because there's going to be a lot of acronyms thrown around and different things. The other piece is the Emergency Family and Medical Leave Expansion Act. I'm going to be referring to that as the FMLEA. And really what that is that's an expansion of what you typically know as family and medical leave under the FMLA. So FMLEA, think of it as just an expansion of that with a limited scope that relates to COVID. And then we're going to briefly talk about tax credits today and how they relate to EPSLA and FMLEA. Just be aware, I'm an employment lawyer. I am not a tax lawyer. And so I may not be able to answer all of your questions. I have, in a lot of these webinars that we've done, I've had a cohort with me, another attorney, one of my tax attorneys, like Brad Lowe and others who really can do a deep dive into these things. So if you have questions that I can't answer, I may refer you to Brad, and we can probably get you the information you need because, again, I know the employment side, I know what the tax credits are, but how they exactly apply, is a little beyond me just because I don't normally know taxes, and I can talk about what they do, but how it may affect your tax liability, I can't speak to perfectly. So anyway, let's go ahead to the next slide. We're going to start off by talking about this EPSLA and what it means. Next slide, Drew. Now, as we look at this, again, it applies to employers with under 500. Now, I think it's important to know how and when you figure this out. 500 employees, you calculate on the day that the employee takes the leave. That's a little bit different than some of the other leave laws that we've had in the past where you look back and what you had in the previous year and different things like this. This is on the day of. And if your number of employees fluctuates, that can change from day to day. And so you may have, if you had 501 on one day, 499 the next day, the law may apply to you and then it may not. As far as the requirement goes, it's up to 2 weeks of paid sick leave. Now, what 2 weeks means here, for at least a full-time employee, is up to 80 hours. And the reason why I say that is, if an employee typically gets overtime, but they're a full-time employee, if they work 50 hours a week, they aren't entitled to 100 hours. They're limited to 80 hours of time total for that paid sick leave component. And part of the key here to both of these, both the EPSLA leave, which is the paid sick leave, and the FMLEA, which is the expanded FMLA, is they only apply when an employee is unable to work or telework. In this day and age, most people aren't going into work. We got these stay-at-home orders by different counties and things. You have the directive from the governor who's saying stay at home. And so in many cases, folks, unlike me right now, are not coming into work. And because of that, you can't define not working as just staying at home. If you're able to work remotely, do some sort of telework, then the law does not apply to you or to the employee to which it would apply. And another key thing here is that this is in addition to any other sick leave that somebody already is entitled to. For example, if you have an employment policy, a collective bargaining agreement that requires sick leave that's paid, this is above and beyond that. And you can't run them concurrently. You can't do them at the same time unless the employee agrees. And I'm not sure what employee would agree to that if they know they can get away with having double sick leave. Now, of course, your sick leave policy is going to have to apply. So you'll have to look at your own policies and how that works. But let's look at how this applies. Drew, next slide. First of all, as I mentioned, it's limited to 80 hours of leave, but part-time employees are also entitled to this. And the way you determine that is you look at the average number of hours that they work. And you can look back to a 6-month period to determine what that average number of 80 hours is. It's not just the 2 weeks immediately preceding the leave. And you just get their average number of hours. Interestingly, for folks that are paid on a nondescript or non-hour basis, you typically would determine how many hours based on the amount of compensation they would receive, and you pare it down to an hourly rate. For example, if somebody's full-time, they'd get 8 hours of leave, but if they get paid on a commission basis, and the way you determine that is you would look back on that 6-month period, determine how much they got paid per week, and then extrapolate that out and figure out their hourly rate and do the 80 hours for those individuals.
Ryan,
yes.
This is awesome. I've got a couple of questions that just came in.
Sure.
Blaine said, did Ryan just say that if they are able to telework, they do not qualify, or did I hear that wrong?
Nope, that's exactly right. If somebody is able to work, then they aren't entitled to the leave. Now, there can be questions as to what that means, and maybe some of you will have questions along those lines. I'm happy to talk about that. For example, well, what if somebody's, and this will come in here in a moment, and it'll also come in under the FMLEA leave, but if somebody's staying at home to care for a kid, for example, well, can't they actually work? That's really hard to define because they're certainly home, but they also have to care for their child. And so what that means and what that looks like, employers are being encouraged to be flexible on that. But it is true that even if somebody's sick, but they're able to telework, then yes, they are technically not entitled to the leave.
Blaine says thank you. Eric Peterson is also asking for, yes, we will make these slides available to the group. We've added it to the event, so you may get an email. If not, we will send these out to you. And then Jacob said, Haney is asking, are these only applicable if the employee has tested positive for COVID-19 or somebody else? Are you supposed to just judge this through good faith that we have employees, or how are they deeming they've been affected by coronavirus?
Right. Well, those are the next few slides. So that's perfect timing on that question. We're going to benefit. If you find somebody use these, obviously a claim can be made. Okay, so let's actually answer that question, Logan, that you just asked. And there are 6 occasions when this EPSLA leave applies. And they fall into 2 camps. And so I'm going to break them apart, the 6 types. There's 3 and 3. And the reason why we do this is because the amount you have to pay somebody fluctuates depending upon the reason why you have to pay them. So the first 3 fall into the camp where you would have to pay them 100% of their regular rate of pay. And that's these three occasions. And this, it would be a situation, for example, where somebody tests positive. But let's run through the three situations. And again, this is when they're unable to work or telework. And because the employee, one, is subject to a federal, state, or local quarantine or isolation order because of COVID-19. Now, one thing I want to say about that is, as I understand that, and it is a little unclear, but as I understand that, if you get one of these stay-at-home orders, we have a few counties that have done this. You've got it in California going on in other states. That's not what we're talking about. This is when an individual is put under a specific local quarantine order that affects them. So, or that they're in a small region or group of people, but it's not just a statewide. This is when the government comes and says, hey, Joe, we're worried about you, the contacts you've had, the places you've visited, whatever, we're going to quarantine you for a couple of weeks. Relatedly is the second category, and that's when a healthcare advisor, which could be a doctor, it could be a nurse practitioner, it could be a lot of different people, as long as it's a medical provider, advises somebody to self-quarantine. So it doesn't just have to be a government order, it can also be a healthcare provider. And then this last one is when they're experiencing symptoms of COVID-19 and they need to get a medical diagnosis. And falling under that would be a situation where somebody has, in fact, tested positive. And so those three categories are the type where you have to pay them the 2 weeks of leave, again, full-time employees, 80 hours, at their regular rate. Okay, so let's talk about, there are some caps applicable to that. Drew, next slide. And so to pay somebody at their regular rate, you only have to pay them up to the cap. And that is $511 per day, or a total, that's actually a typo. It says aggregate limit. The aggregate limit is $5,110. I guess I missed the changing the 1 to a 0, but basically, as you can tell, it's 10 days worth, or the equivalent of 10 days worth of leave on that, which would be, of course, 2 weeks for that cap. And the reason why these caps may be important is the caps also are going to tie into the tax credits that we're going to hit on, because that's the maximum tax credit that you could claim for the EPSLA leave. If an employer goes above and beyond this and says, hey, I want to pay them their regular rate, 511, they get paid more than that per day. Well, you can pay them their regular rate if you choose to do so as a kind, benevolent employer. But you, as far as the tax credit goes, you don't get anything more than what these caps place. Let's go to the next slide. This next slide addresses the next three areas that paid sick leave comes into play. But in this case, an employer only has to pay 2/3 of the employee's regular rate. And so that is the distinguishable difference between the two. In these three cases where this applies is when somebody takes off work to go take care of somebody that either is under a quarantine order or has been advised by a healthcare provider that they need to self-quarantine. So it's kind of the first two that we saw in the last slides, but this is when it's not yourself. This is when you're taking care of somebody else. The other reason why you might be entitled to 2/3 of your regular rate of pay under this paid sick leave is if you take off to take care of a child, and it has to be your own child, under the age of 18, if a school or daycare closes because of COVID-19. This might be a common one right now because schools are out. They are closed. Technically, an employer can ask for proof that a school is closed. We all know, right? I don't know that you really need much proof here. What you may need is some proof that this person has a child who would be attending that they need to go take care of. And then the last area, and I'm not aware of anything that would fall within this yet, but this would be a case where you would have a substantially similar condition that the Secretary of Health and Human Services defines as something that would fall within this. At this point, I'm not aware of anything, but something certainly could come up. I think the most likely one here again is the school closure piece. Logan?
So Ryan takes leave to care for school or is closed.
Right.
That impacts like 90% of employees.
Sure. Absolutely. I mean, that's now remember though, they have to be unable to work or telework. And what does that mean? And you can also take this leave if the employee and the employer both agree. It could be taken intermittently, which means you could take it piecemeal, a little bit here and a little bit there. But as far as this goes, the absolute leave, though, if you do it intermittently like that, it has to be on a day-to-day basis. So you can't say a couple of hours here, a couple of hours there. It's in full day increments. Now, that's a little different than what we're going to talk about in a minute when we talk about the expanded FMLA leave, because that can be taken in various increments. But on this one, it has to be full day increments. So you could like take Monday off to go care for a child, but then work Tuesday. You may say, well, Brian, when would that come up? Well, what if you have two different parents who are both trying to take this leave? One could take Monday, one could take Tuesday to take care of the child. And that might be why that would come up on a fairly regular basis.
How is the government determining can telework?
So basically, that's if you have the ability to work from home, that's going to count. It's not just whether you can log in. I mean, if there is work that can be done remotely, then that is going to count. It's going to basically be very similar to what we define under the Fair Labor Standards Act definition of work, which would be being permitted to work. If there's anything you could do for remotely, if you can answer emails, answer the phone, so you don't even have to be on a computer. You know, if everything you're making sales calls via telephone, that is going to count. And so any work that can be done will fall within that. And I think that is the biggest limitation on this act. And it's probably the one that people pay attention to the least.
Thank you.
Let's go to the next slide because there are also caps on this. They're significantly reduced. The cap on this is $200 per day, or an aggregate of $2,000 for the three reasons that we were just talking about. Let's hit the next slide. And again, those caps are also tied to the tax credits. The only difference is there is a component there of an aggregate of $10,000 on the tax credit, and we'll talk about that in a minute. But let's turn now to the Emergency Family and Medical Leave Expansion Act, or FMLEA as I call it. And really this is an expansion of what most people know of as Family and Medical Leave Act leave, or FMLA leave. And it expands what's available under the FMLA in one situation. And that is when an employee takes off, again, they're unable to work or telework, to take care of the son or daughter because the school had been closed. Basically, this is that fifth category we just saw under the paid leave. And you may say, well, Ryan, why is it under both? Well, the reason why is under this expanded FMLA leave, you're entitled to up to 12 weeks of leave, whereas the paid leave was only 2 weeks or 80 hours for a full-time employee. This is 10 weeks worth of leave that can be taken off to care for a child. And the difference between this one and the last one is, for that last leave act to apply, every employee you have on your books is entitled to take the leave. In this case, it's only employees who have worked for at least 30 days. Now you may ask, well, what does that mean? And what the direction we've been given from the DOL, the Department of Labor, is that it means if the employee has been on payroll for 30 days, that counts. And as you quantify that, you can even look like if you had a temporary employee who then became full-time, you can count the time that they spent as a temporary employee in that 30-day calculation. Let's hit the next slide. Now, what's interesting about this FMLEA, and that's in contrast to the FMLA leave, is, as most of you probably are aware, FMLA leave is not paid. So traditional, let's do a quick background on what traditional FMLA leave is. Most of you probably are familiar with it, but if not, it's good to understand what there is. An employee can take up to 12 weeks of time off. It's unpaid, and it's what we call job protected, meaning when the employee returns to work, they're supposed to be restored to the same job or substantially the same job with the same pay, benefits, etc. They can't be have anything reduced. This expands that, but it's slightly different in a couple of different ways. As I mentioned, this applies to any employee that has worked for 30 days. Traditional FMLA leave, the employee had to work for you for 12 months, and they had to have worked at least 1,250 hours in the prior year. Those requirements don't apply to this expanded leave. What's interesting about this expanded leave is it's still 12 weeks. And yes, this is a question I've heard repeatedly. It is part of the total allocation of leave under FMLA. At least that's the position that the Department of Labor has taken. So for example, if an employee had already taken 2 weeks of leave in January because they were out due to a serious health condition, they've returned to work and now they're going out to care for a child under this FMLA leave, that employee now, even though they should have an allocation of 12 weeks, only has 10 weeks because they've already used up 2 of the 12, if that makes any sense. A couple of other differences, though, between this and traditional FMLA leave is, unlike traditional FMLA leave, there is a paid component to the FMLA. Now, the first days are unpaid, the first 10. However, if you're already doing the math, 80 hours or 2 weeks is the equivalent of 10 days if we assume a 5-day work week. And so if an employee they can take the EPSLA leave, which is paid, as you recall, to care for a child at a 2/3 rate during those first 10 days. So even though the FMLA is unpaid, the employee can substitute in the EPSLA leave. The two can run concurrently, but then you would have to pay them. And then under this leave, this component of leave, the expanded, the employer has to pay the next 10 weeks of the leave at a 2/3 rate. So what does this effectively mean? If you use the EPSLA leave for the first weeks and then the FMLA for the last 10, yes, you basically could pay that employee for a total of 12 weeks at a 2/3 of their regular rate when they're out to care for a child. And again, this can be taken intermittently. This, unlike the EPSLA leave, you don't have to do on a day-to-day basis. This could be in any increment that you desire, as long as both the employer and the employee agree. So you'd have to work that out. You'd have to work on schedules and different things. Now, one thing that doesn't make any sense to me, and so I'm basically telling you kind of a loophole, or I don't even know if it's a loophole, it's kind of a crazy thing in the law that I'm not sure how to reconcile it. And even the DOL's regs and things have not clarified this, is if you take leave intermittently, well, doesn't that mean you can work? Because the DOL seems to be suggesting that you could work for a few hours here and then take a few hours off. Well, how can you be able to work at one point and not another point? The only thing I can imagine is a situation, for example, where you're splitting, a couple of spouses are splitting, caring for a child, or they have another caregiver who can come in. And so they're unable to work from noon on, but they are able to work in the morning. And in that case, they would be able to take that FMLA leave intermittently. The other thing, go ahead.
Floyd asked a question that might be, that we may have just answered, but or maybe in addition to what you just said. He goes, so if I have an employee that is a developer and can work remotely without issue, the employee has 2 young children and has expanded the nanny's time to care for the children when they would have been in school, does this employee qualify for either?
Well, if the employee can work, because if the nanny's taking care of them and they don't need to take the time off to work, then I would say no, they don't qualify for the leave. The fact that they're home and not caring for the child is not entitled them to the leave. They actually—
the fact that they hired the nanny disqualified them. If they never would have hired the nanny, they might have qualified.
That's probably correct. Yeah, I think that's right. And they're paying that person. So effectively, even if they're working from home, they're still working, and therefore they're not entitled to leave. And I may say something obvious as a corollary to that. If somebody is off, I mean, obviously, if you're unable to work, then you're not getting paid. And so this is leave to cover times when you wouldn't get paid. So a person can't both get leave pay and get paid for doing work. I mean, I know that's obvious, but Just want to make that very clear. You have to be unable to work. And so having the nanny there could free you up to work. Now, I think an interesting question is, well, if you have the nanny, but you're not able to work for whatever reason, you can't, the work you do has to be, you're a factory worker and you have to be on site and you've been ordered to stay home. Well, you have this nanny now. Technically, you can't work, but if you're not caring for the child, you still aren't entitled to the leave. So I hope that answers the question. Why somebody would hire a nanny and not take care of the children, I don't know. I would only hire the nanny to work, but I hope that answers the question. If not, follow up, Logan, and we can touch on that more. The last thing I wanted to hit on this slide, it's right at the end there, and it's the caps that are applicable to the FMLA leave. This is $200 a day. So again, anytime you have the 2/3 rate, the daily cap is $200. The difference here, unlike the EPSLA leave, which you recall was a total of $2,000 or the equivalent of 10 days worth, here you've got a cap of $10,000, which, doing the math again, this is going to be the remaining 10 weeks of paid leave. So there is a method to their madness, as you could say. Let's hit the next slide. Okay, returning to work, much as I said, traditional FMLA is job protected and FMLA leave is no different. So if somebody goes out to take this leave to care for a child and they come back, they have to be restored to the same job or substantially the same job. There are only a couple of exceptions to that. One is an employer with fewer than 25 employees. Now, to qualify for this, if an employer has fewer than 25 employees, they still have to meet the rest of this test, and that is their position no longer exists because of an economic downturn related to COVID or because of some other issue related to COVID. You've just shut the business down temporarily or what have you. And the employer has to make a reasonable effort to restore the employee to an equivalent position within 1 year. And that includes if a job comes up, the employer has to tell the employee about it so that they can move into that position. The other exception, which I don't have on the slide, is what has traditionally been called a key employee exception. And key employees is already a concept that was under the FMLA. And this concept is usually for managers, things like this, people that are in positions that you just can't easily replace, that if they go out, you can't have two of this position. It's like the CEO or the CFO. And traditionally, these are employees that are the highest wage earners at your work site. And that's part of the reason why. So you have to look at that key employer language to see if that person is carved out. Let's turn to the next slide. Okay, so let's talk about employment policies under the Act. And all I'm going to say here is I think it's wise, just like with any other law, to update your policies. One thing I need to say here is there have been questions if an employer already offers paid sick leave and now they've got to do this, can they just wipe out their other policy? Can they make a policy change? And I'd say the answer is no. By doing that, I think that there's a risk of penalties and fines and different things. Because again, remember, this is in addition to any other paid sick leave that they may be taking. And you ought to make these changes to the policies and things as soon as possible because this act is going into effect fairly quickly. A couple of other things that I ought to say about this. It was probably on prior slides, and I probably, as I was trying to get through the material quickly, didn't touch on, and I should do so now. First of all, there is an exception for employers with under 50 employees. Now, they're not carved out of the Act. All employers under 500, so 499 and below, are subject to this Act. However, employers with under 50 can ask to be exempted from the application of this statute. Now, the DOL doesn't want a lot of information. They're busy right now with everything going on. They don't want a lot of information. So to a certain extent, they're going to take your word for this. But what you basically have to do to qualify for this exception is you have to say, look, I have under 50 employees, and if I have to pay these leaves, this is going to put us under. It's going to affect the economic viability of the company, and therefore we should be exempted from the act. And as of right now, I think that the government will just kind of take your word for it, but it has to be done in good faith. Whether they may come back retroactively and look at whether it was proper, that may happen. And so, I wouldn't just try to pull something over on the government and not paying these leaves. I mean, certainly, even if you're a smaller employer, I would still try to comply with the act. The second thing I would say about calculating employees, the number of 500, you count everybody with the exception of independent contractors. I mean, you count your seasonal employees, you count your temporary employees, you count all of your part-time employees. Everybody figures into that number. And as I already mentioned, you calculate that on the day that somebody is asking about the leave. The other thing I would say before I delve into the tax credits is that for these leaves to apply, not only does the employee should not be able to work, but they have to be able to qualify under the individual requirements that we've already discussed, like the 30 days for FMLE and things like this. And by the way, if somebody is sick with COVID, they only get the 2 weeks of paid sick leave. They do not qualify for the expanded FMLA. Having said that, they could still take regular FMLA leave, which still is in effect, but they have to qualify, just as we talked about previously, that they had to work for you for 12 months, they had to work 50 hours, and they have to have a serious health condition. They can also take regular FMLA leave to go out and care for somebody who has a serious health condition. So,
Ryan, quick question. So, if you do have paid sick leave,
yes,
and they do not qualify for this act.
Okay.
No, and they do. Sorry, if they do have paid sick leave,
right,
and they do qualify for this act, do they essentially make twice the amount while they're out, or does this act only apply once the paid leave they have has been used up?
Okay, so what this would work is usually they will not run concurrently. They would typically run back to back. And keep in mind, some of the paid sick leave, depending on the reason, is only paid at 100% rate, and other leave under EPSLA is paid at a 2/3 rate. I'm assuming the policies of the employers traditionally is going to be that you have to pay them at 100% rate. So pay attention to which leave they're on, because that will dictate how much has to get paid. But typically you would do one leave and then you would do the other. And keep in mind, the FMLE leave, the expanded FMLA leave, only applies in the one situation when somebody's out to care for a child. So if they're just out sick with COVID, they only get 2 weeks of paid leave under this act, even though they could take FMLA leave and have unpaid time off. However, if an employer then has a paid sick leave policy, they could take those back to back, and they would have to pay them at whatever rate they would normally pay under their own sick leave policy. And you could do those technically in either order. That I don't think matters. You just can't couple them together. The only exception is maybe if an employee agrees to allow you to run them concurrently. And again, I don't know why an employee would do that.
Okay.
Did you have another question, Logan?
Nope.
Okay, perfect. So that's kind of the guts of the FMLA leave. One other exception I ought to say is there is an exception that may be taken advantage of for employers that are employing healthcare providers or emergency responders. And in those cases, an employer can opt not to give the leave. And I think the rationale behind that is basically those employees may be needed to work to respond to COVID-19. Now, that works if somebody's taken off time to go care for a kid. If somebody's got COVID, you certainly don't want them on site. So I would be giving them the leave. But be careful that you are even-handedly applying that exception. You don't want some sort of claim of discrimination or something under, you give the leave to the woman, but not the man. And all of a sudden now you've got a gender discrimination claim or something like that. So you need to be careful. The other thing I would say is for public employers, as opposed to private, sometimes these acts don't apply in the same way. We're going to talk about the tax credits. They don't apply to public employers, and federal employees may not be covered by the expanded FMLA. They have coverage just the same as they would under normal FMLA, because federal employees typically are under Title II of FMLA rather than Title I, which means they don't get the same leave rights as other public employees and private employees. So unless there's any other questions about the leave, I'm going to turn quickly to the tax credit. So go ahead and change the slides, Drew. And as we get into this, I guess, do I not have the slides here for the FMLA leave? Maybe they got taken out. The slides may have been taken out on tax credits, and I'm not sure why that was. I thought they were in here. Maybe it's because some of the leaves that we had when I used these tax credits previously were with my partner, Brad Lowe. But let me kind of hit from a high level what these tax credits are and how they work, and just to give you a flavor of them. And again, if we have questions, feel free to ask them. If I can't answer them, we can probably get somebody who can. But basically, businesses are able to take advantage of various tax credits that go hand in hand with these leave provisions to offset the costs associated with the paid emergency leave and sick leave benefits that are under the FFCRA. And basically, it's 100% of the leave. Now, admittedly, it doesn't address cash flow, so it's not going to affect you on a day-to-day basis. But where the tax credits can be beneficial is they can be taken on a quarterly basis, which means that you can seek these tax credits every time you make a quarterly tax filing. And the way you would do that is just by using the traditional Form 941, the employer's quarterly federal tax return. You would use that form and you would report it on there. My understanding, and again, I'm not a tax expert, is that they were going to modify that form so that you could take these tax credits. And one other thing that you should be aware of on this law is its duration. I spoke about how it went into effect on April 1st. It only is in effect until December 31st. And the reason why that matters is you're only able to take the tax credits during that time period or for those quarters, but you also only have to pay the leave during those quarters. If, for example, somebody started taking paid sick leave on December 26th, let's say, and they took it through the end of the year and they wanted to have 2 weeks worth, well, under this act, you only have to give them 1 week's worth, because then the act would come to an end. Some other things that are important to understand is the tax credits are refundable. And what I understand that to mean is that in the event that, well, essentially, you're able to take the full amount of the refunded tax child care tax credit for the payment of expanded paid family and medical leave equal to 2/3 of the employee's regular pay. Again, the 2/3 coincides with the amount that you're required to pay under the FMLA leave. And you can take that 100% of that up to those caps we talked about, which is $200 per day, for a total aggregate amount of $10,000. When you do that, it's only for the period, and if the amount of the tax credit exceeds the employer's portion of the federal employment taxes, then any excess is treated as an overpayment, and that is refunded back to the employer. So that's what I mean by refundable tax credits. In addition, of course, the federal employment taxes that are available for retention it's retention by eligible employers includes the federal income taxes withheld from employees, the employee's share of any of the Social Security or Medicare taxes, and the employer's share of Social Security and Medicare taxes with respect to all employees. So that's where that benefit can come in on the tax credit. The other thing that I understand is not only do you have to claim the credit, But there are times when you can just not make the tax deposit that would normally be required, or you can reduce the amount by the amount of the credit that you would be entitled to take. Now, if you don't make those deposits, obviously when you submit that Form 941, you're going to need to put on there that that is the case, that you took that credit. And by the way, you would only be entitled to not or to withhold those tax deposits or reduce the tax deposits under 3 conditions. First of all, it has to be that the eligible employer paid qualified leave for under these 2 laws that we talked about during that quarter that you're not making the deposits. Second of all, the amount of the federal employment taxes that the eligible employer does not timely deposit is actually less than or equal to the amount of the eligible employer's anticipated tax credits, and that these qualified leave wages for the calendar quarter as of the time of the deposit. And then the last thing is the eligible employer did not seek a payment of an advance credit by filing the Form 7200, the advance payment of employer credits. Obviously, if you've already received a credit in advance, you wouldn't be able to withhold those deposits or reduce the amount that would be submitted. And, as I mentioned, governmental employers typically are not going to be eligible for the tax credits. I don't know that we have any of those on, but they should be aware of that.
We have people on that have government contracts. Is that?
Say that one more time, Logan. You cut out for a second.
We have a couple people on that have government contracts, but they're government employers.
Sure.
So they're fine?
Yeah, they would still be considered a private employer, as I understand it, under the Act. Certainly, I mean, you would pay your taxes as normal, just as you normally would, but I understand that though folks with private employers with governmental contracts would still be considered private employers for purposes of the Act.
So Ryan, one last question for you. We have a lot of people on that, well, let me back up. Through some of these acts, the government has made unemployment much more enticing than they used to. Right?
Sure.
So a lot of people are decreasing people's hours so they can go claim unemployment, or furloughing them so they can claim unemployment, but still paying their health insurance. Like, are there any risks that our employers are running? Are there any risks there? And if not, then it's like, no, just make smart decisions. But what risks?
Yeah, I guess it depends on what you mean by risk. I mean, obviously, in some cases, there's been some augmentation and things to the amount that employees can get, or former employees, in unemployment benefits. The state basically is allowing something that traditionally doesn't allow, which is if somebody's not working or having reduced hours because of COVID, they might be eligible for unemployment benefits. But if somebody's receiving an unemployment benefit, they can't double recover. So you can't get paid leave and unemployment benefits. So if somebody is out on paid leave, it's just as if that person is still employed, and they would be ineligible for unemployment benefits, even for these reduced ones. Now, if somebody is let go because of a shutdown or a furlough or a layoff, something along these lines, because of COVID, because the way the economy is affecting a business because of COVID, that employee then, of course, can, in their normal course, go and apply for unemployment benefits. But once they're laid off, they are not entitled to these leave provisions. And so, of course, these are only available when an employee is working. Now, again, you need to be careful that if somebody comes in and asks to take the leave, they can't just be, quote unquote, laid off and tell them to go get unemployment, because the problem is, we already talked about, you cannot retaliate against an employee for exercising their rights under the Act. The only way you could let them go while they're out on leave or at the time they've requested leave is if they were going to be let go anyway. And you would basically have to prove that. Now, the shutdown of an entire factory or an office, or laying off of all the workers in a particular category, that's probably easy to show. If you're just getting rid of one employee who just requested leave, that's going to be a tough sell. And you may want to just give them the leave anyway. So those are some of the risks that I think that might relate to the unemployment piece that you talked about.
No, thank you, Ryan. I think my third call now doing interviews like this with people, and I think the biggest policies is like you cannot double dip. Ryan, thank you so much. I think this is gonna end perfectly. I don't have any more questions. If you have a question, speak up now. Ryan, any other closing thoughts or comments?
No, I mean, there's a lot here to chew on, and so hopefully we can get you the slides available. In fact, I think what I will do, because apparently the pieces relating to the tax credits are missing from the slide deck, I'm going to send Logan an updated slide deck and to Drew that would have included those slides, so that at least you can take a view of what we had in those. I don't know how I got you a slide deck without the tax credits, but that may create more questions. Certainly, if there are any, if Logan shoots me an email or something with a question, we'll do what we can to get that answer. So.
Cool. Thank you so much, Ryan. I now have a better understanding of why you're so busy, because this is a lot and it's complicated and it's moving. So I'm grateful that there's experts like you out there. Some of you may have seen that yesterday the U.S. Department of Treasury released a press release. I'm talking about how the Treasury and Federal Reserve Board announced a new and expanded lending program to provide up to $2.3 trillion in financing. This is basically the Fed's response to help out the middle market. A lot of the PPP loans was just was focused towards small business or 500 employers or less. This new lending program will be for that middle market of 500 employees and above. That press release was released yesterday. Our experts on this call still know nothing more than just what that press release says. So hopefully over the coming days, they will release more on qualifications, requirements, and process. As soon as we have all of that, we may have one of our experts join for a couple minutes on next week's lunch call in the beginning to review that real quick. But just for those of you that are in that middle market, there is something coming for you. Stay tuned. We hope to be a resource for you there. Again,
Logan, if I may, just really quickly. Also, one thing that everybody should be aware of is if you still have questions about this FFCRA, the DOL has put out, you can of course read the regs, they're fairly lengthy and complex, but they've also put out a nice question and answer. I think there's about 60 questions, give or take a few, that answers a bunch of questions that folks have asked the DOL. And that might be also a good resource you can find on the DOL's website to answer some of the questions you may have.
No, thank you, Ryan. And then big thank you again to our sponsors, Visible Supply Chain Management, Alexander's, Mountain America Credit Union, EY, and Snowbird. We will see you all next week at our Truss lunch, our virtual Truss lunch, noon next Friday, and then Chad Hymas the following Friday. You will receive an email today with these slides and with announcements of the upcoming events. Thank you so much. If you need anything, if you want a connection or additional information on something, reach out to us and we'll get you connected. If not, happy Friday. Thank you, guys. Thank you.
Thanks, Logan.
I'm going to stop the recording.